Okay, good. Yeah, Tim, I hope you don't mind that we record the session, and Kathy also.
Fine.
It's okay.
Yes.
That's fine.
Good. So that the people who missed the meeting can come back and listen to the seminar.
Can I edit it after I look at it?
No, it's be a fine.
That's a good one.
Don't worry about it.
All right, okay.
I'm not an attorney, but I'll make the disclaimer. This is being used just for Coldwell Banker Georgia
Yes.
exclusively.
Yes.
It is for educational purposes, and anything said here is not a client lawyer explanation. So
Wait a minute.
let me mute everybody.
I just pulled the plug a little too. Hold on.
7.
So Peter, you're welcome to unmute yourself and do the introduction for.
Okay, all right. Good morning, everybody. Welcome to the commercial meeting. As I always said, I am always looking forward to the commercial meeting because we always have a very nice keynote speaker, and it's very informational and educational. And no exception today, we have the two very great speaker. I can assure you that we will have a very nice and educational meeting today. But before I introduce them, I would like to tell you some good news about our company. And this year, we are qualified for the Chairman's Circle as well as the President Elite Conference with the Coldwell Banker home office. Normally, over the last 20 years, we always can make it to the Chairman's Circle, but this year we made it to the President Elite as well. President Elite is the commercial section of the real estate, and I'm so glad to tell you that we make it as well. So James Chow and Jimmy Cam and I will represent the company to the Chairman Circle, and Caesar will represent the company on the commercial section. So I'm happy to tell you that, and I thank you for your effort and for your support. Without you, it would not be possible. So I thank you for that, and hopefully we can continue our momentum this year, and we will have a good 2021 in both residential as well as commercial. Okay, with that, I would like to introduce our guests today, keynote speakers. We have two speakers today. One is Catherine May, and the other one is Tim Murakami. Now, Catherine has been in real estate for over 37 years. She was the principal of South Bay Developer Services Processing Business for 17 years. She has spoken before the California Land Surveyors Association and Building Industry Association. She was on the LA County Assessors Advisory Committee, and she has written for California Title on Property Tax, Segregation for Subdivision, and Subdivision Manual for Developer. She assists developers, attorneys, and engineers in tax clearance, lots line adjustments, easement quick claims, property tax, estate planning. So she is very a wonderful speaker, and she has spoken before a lot of groups. And the other speaker is Tim Murakami, renowned attorney in the San Gabriel Valley area. And I have known Tim for over 35 years. When I first met him, he was the newlywed to my wife's best friend. And so we've been going a long way. Professionally, he has been an attorney for over 40 years and specializing in common interest subdivision laws for the past 35 years. He has prepared governing legal documents for thousands of planned developments and condominium projects in California. He has worked with the big and small projects, including golf course housing developments, multi-phase planned developments, single-phase condo projects, condo conversions, and mixed-use residential and commercial projects. He was also involved in the enactment of changes to the government code section pertaining to the conversion of stock cooperative and community apartment projects. And in summary, he is probably the most experienced land developer attorney you can find. So without further ado, I would like to welcome Kathy and Tim. Thank you for coming to our meeting. Let's welcome Tim and Kathy. So Tim, can you unmute yourself, and Kathy too? And I don't know which one will go first.
Yes. Okay, I'll go first. I'd like to thank you, Peter, for inviting me to speak. It gave me months to worry about something and gave me a chance to put my suit on. I haven't had this on for a while, and to clean my office. I'll go first. Kathy and I have worked together for decades. I'm that old, but don't get me wrong, Kathy was 10 years old when she started working. So she's still young. Anyway, we're primarily going to talk about commercial and industrial projects. And let me start by talking about the types of projects I would get involved with. It could be what we call a standard project, which would be buildings that are individually owned on a separate lot, but maybe the different lots and buildings are tied together by easements, and it's part of one project. So in that situation, maybe I'm called on to prepare easement agreements, and then maybe CC&Rs that relate to how the different buildings cooperate with each other, architectural control and use restrictions. So that would be a standard project. From there, there could be projects that are where the individually owned units or buildings are more tied together. It could be a planned development, which used to be called the PUD, planned unit development, but the code section now calls them planned development, although you'll hear that term PUD quite often still used. Those would be where the buildings are individually owned and located on separate lots or parcels, and there may be a separate common area lot. And therefore, there have to be CC&Rs that are prepared and recorded against the property. And the CC&Rs would call for a setup of an owner's association, much like a homeowners association for a project, a tract project. So that's a planned development. Then there's the condominium projects, commercial, industrial, where under the code sections and the way it's set up under the subdivision map, the units or buildings would be located on one lot, and the owners would get an undivided interest in that lot, and the rest of the lot, exclusive of the buildings, would be common area. So that situation, of course, you'd have to have CC&Rs. Let me back up. One of the major breakdowns of the projects would be whether it's new construction or a conversion of existing buildings. And Kathy will talk about the processing with the city as to those projects, whether it's new construction or a conversion. Now, I mentioned the commercial and industrial, but also I get involved in shopping centers. In shopping centers where there's individual buildings that are part of a unified shopping center, but they're individually owned on separate lots or parcels. And if they're separately owned, then they need some agreement, CC&Rs and easement agreements that that unify the project and talk about the cooperation that the different parcel owners will have to comply with, so that it keeps a uniformity uh, and also sharing of expenses. Now, I had mentioned planned development and condominiums. Those are considered under the Civil Code, California Civil Code, as common interest developments. Much like a residential project, whether it's a condo or tract project with a private street, for example. In 2004, before 2014, there was what's called the Davis-Sterling Common Interest Development Act, which governs the setup and operation of homeowners associations. And if it's a commercial industrial, then we just call it an owners association. So both types of projects, that is the residential and commercial and industrial, used to be covered by the same code section, Davis-Sterling. But in 2014, they separated out the legislation. So there's a separate Davis-Sterling Commercial Industrial Common Interest Development Act that now applies to those projects. And without getting into details on the differences, what the Commercial Industrial Act recognizes is that the owners are more sophisticated than the residential project, and therefore the legislation is not as specific as to consumer protection issues. And so there's more leeway on how these commercial industrial projects are set up. Also, Kathy and I could get involved in and have been involved in mixed use projects, usually condominiums, where there's a residential condominium units and then there's commercial condominium units. I'm sure you're familiar with that. Now, strictly commercial industrial projects do not have to get a public report through the Department of Real Estate for the developer to enter into the sales program. Residential projects consisting of 5 individual units or more would have to be approved by the DRE. If it's a mixed-use project where there's at least 5 residential units, then even if it's a mixed-use project with commercial component, the DRE will review all the project documents, including the commercial documents, as part of their review of the sales of the residential units. There are some mixed-use plan developments, but we don't see it as often. And as you probably know, there's a lot of mixed-use condominium projects. I will get into more detail on the setup of these different types of projects and the documentation. You've heard of CC&Rs and all that, but I should let Kathy take over and talk about the city processing of these projects.
Okay, thanks, Tim. Thanks, Peter, for inviting us today. As Tim had mentioned in the city process, because we're talking about subdivisions, and subdivisions are a discretionary approval. So the application to the city is an important one. Really the underlying differences between the commercial industrial condominiums and the residential condominiums is the zoning. So because of this, application for approval by the city is important, but it is an investigation that can be fairly easily done on the city level and may or may not, cost the developer any money to do it. So in going to the city, sometimes you can go online and gain the information that you need. City of Los Angeles, for instance, has a great site called ZMIS, and there's a lot of information that can be given. In the San Gabriel Valley, you have a lot of individual cities, but they're over-the-counter. People are, very friendly and cooperative, and it's, can be pretty easy to go in and say, here's my property, and here's what I'd like to do, and what are the guidelines. On larger projects, you usually find that the architect will complete that review, but essentially what you're looking for is how big of a project can you develop. A lot of that has to do with parking. For commercial and industrial, parking has to do with what the type of uses are. So once that investigation is done and the developer has settled on what he wants to develop, then he'll enlist the services of a civil engineer, and that engineer will prepare a tentative map. The tentative map is going to have everything on it about, well, sort of his wish list. This is the parameters of my project. This is the square footage or the number of units, depending on the type, number of parking spaces and whatnot. That gets submitted to the city and it goes through a review process. All the different departments are going to look at it. And because, as I mentioned, it's a discretionary approval, those departments will put some conditions on it. Public Works, for instance, may want street widening. They may want sidewalks redone, curb cuts put in, taken out, street lights, traffic lights, things of that nature. And those will all be requirements of the developer at when he does his construction. And therefore, they have engineering plans that go with it. And all of that just, becomes a cost factor as the developer is looking at doing what he wants to do. If it's a conversion, it's a little different in that the building is already there. And essentially you're going in and talking to the city about the types of uses that you want to be able to allow. And those uses tend, again, to be restricted by parking. So once those things are decided, you have your application in, you decided what you want to do. The city departments have reviewed it, put on their conditions, and then you go to a public hearing. So you will be subject to notification to the general public, and there will be a hearing about it, the same as there is with the residential condominium. Planning Commission approves it, City Council approves it, and you are ready to go into the next stage. The engineer prepares the final map, and the architect starts developing his plans. So at that point too, the title company becomes involved because they're going to take essentially what would normally be a title report and turn it into a subdivision report, where they're going to pull out of the public record all of the easements, ownership information, and any lender information. Owners and lenders must sign the map. So if it's sometimes in conversions, the lender is not really aware of what you're planning to do. And when approached to sign the map, it's very much a discretionary approval on their part. And that may not be in their loan documents. So they may, sometimes that forces a developer to go to a bridge loan because his current lender is not willing to execute that map. And without the lender's cooperation, at least in that regard, the map cannot record. So, but assuming we're talking about new construction, you'll be dealing with a construction lender who's very much aware of what's going on and will be very willing to execute this map. So the city has control over the project via the building permit and sometimes a conditional use permit, but definitely through the tract map. And they get what they want. The developer is going to build it for them. Then, however, when you go to the next step and the map's recorded, now you're going into the condominium plan. That becomes a conversation between the engineer and the title company. And the title company is going to review the tract map and the condo plan and the CC&Rs. And what they're looking for is insurability of the legal description. So they're going to review very carefully the condo plan with the CC&Rs to make sure that they're compatible in terms of what is the legal description going to look like and what's going to be sold. So as Tim mentioned, fortunately with commercial condos, you do not have that Department of Real Estate component unless you're dealing with a mixed use. But setting aside the mixed use and dealing strictly with the condominiums, there are a couple of ways that that condo plan can be done. There are some commercial projects that are very clear in the definition of what they're going to sell. The office, for instance, or a medical condominium where the structure of those medical offices is already set by the architect. Then you have a very standard condo plan similar to a residential with units of varying sizes. However, what we're also seeing a lot of is the commercial industrial condo where they have no idea where the walls are going to be. And that all becomes part of the marketing plan of what a person might want to acquire. So in order to move forward and be able to generate a legal description with a condo plan, the engineer will develop it in grids. And those might be 5 foot by 5 foot squares that are mapped out on the condo plan within the dimensions of the building. Then the marketing department says, okay, this is where our walls are going to be. These are the grids that we're going to sell. And you have a legal description. You have a structure from which you can transfer. That's where Tim's documents become very important, because now the CC&Rs have to deal with issues of internal easements. You've got a 5 foot square, but maybe your wall is going to go down the center of it or going to go down the side of it. And you have to have the language to grant and reserve easements so that the person who's buying it gets what he thinks he's supposed to get. And his unit becomes a wall-to-wall dimension, but that is defined through these series of grids. So it also presents an interesting situation when you're talking about grids in terms of your budget, because the budget, as you know, in residential condominiums is so much per unit. And unless the units vary greatly in size, everyone pays the same amount. In a commercial condo, you will rarely have units that are all equal. And so therefore you're looking at a budget that's going to be allocated more by square footage than by the total number of units. Also in those condo projects, you don't really know what your total number of units is going to be. And again, a lot of times that's governed by parking. The parking might be, one space per 1,000 square feet, for instance, something like that. So all of that has to be taken into consideration when you're structuring this project to go to sales so that everything is fair and equitable. I think I have covered, I jumped into the budget a little prematurely. So I'm going to turn it back to Tim to talk about matters of the CC&Rs, and then I'll come back to those budgetary issues, and then we'll talk about phasing and how you carve it up when you're ready to sell one part but not the other part. So
Right.
yeah.
All right. So part of my services, the major part of it would be preparing what's called governing documents that govern the project. And that would include, as we talked about, CC&Rs. There would be the articles of incorporation to incorporate the owners association, bylaws. The CC&Rs are kind of considered the constitution for the project. They're pretty lengthy and they get recorded with the county recorder. So they're kind of the do's and don'ts, restrictions, use restrictions, architectural control by the owners association, covers how assessments are divided up, like Kathy touched on. The bylaws are not recorded, nor are they filed with the Secretary of State, for example. And the bylaws governs the operation of the owners association. That is, who are the officers, officer positions, how are director meetings held, what kind of notice has to be given for directors meetings, for owners meetings, how are votes taken. Also, the CCNRs will usually grant developer control for some extended period of time. And even on residential projects governed by the Department of Real Estate, the Department of Real Estate recognizes the interest in having the developer maintain control for some period of time during the transition period, that this is not just beneficial to the developer, but it's beneficial to the owners during the transition period. So even projects that are not governed by the DRE because there's no residential units, the attorneys will work in declarant or developer extended rights of control, including having additional voting powers beyond what the individual owner would have. Let's see. Kathy talked about the budget and the condo plan. The condo plan, let's talk about the condo plan. Kathy talked about grids, but then there's your typical condominium project where the units, the airspace usually within a common building, is clearly defined. So it's not a question of flexible size as to the units. Those condo plans, we still have consideration of parking, because parking is something that needs to be considered. Are they going to be sold and designated through the condominium plan? So when someone's buying a condominium unit, they know exactly what spaces they're going to get. Or is it going to be assigned during the sales process? Usually we encourage the assignments to be made initially at the outset through the condominium plan, because one of the negatives to waiting until your sales is going on is that the developer would have to, would maybe get involved in negotiation and have to keep track of the spaces. A buyer comes, I want this unit, but I want those spaces. Kathy, can you add to that?
Just that it can be a bit of a nightmare if they're not, if they're not pre-assigned. I mean, there'll be some, obviously the sales force would be involved in initially determining which spaces should go with which units, having to do with location and desirability and things like that. And if it's not preset, it's pretty easy for everyone to forget who has what. And the title company should really not be relied upon to keep track of that. So what happens is that spaces get deeded to the wrong units. Unwinding those kinds of situations is a nightmare because most of the time you have lenders involved, and at that point you may have uncooperative owners. So parking is just something that really has to be paid attention to, as we all understand in California, since we're a car state, right? A parking space can have as much value as as a unit location. So the more pre-planning that you can have to determine the fairness of spaces, the better, and then stick with it.
Okay. back to the CCNRs, important thing I haven't talked about is construction defect, heaven forbid, right? Construction defect claims, which is more of an issue to worry about with residential projects. But with residential projects, there's also what we call SB 800 or California Fix-It Law, which governs how construction defect claims are handled. There's pre-litigation procedures. So if there's a claim made, the owners who are threatening to sue the developer, they cannot automatically file a lawsuit in the courts, that there's a process of going, procedures to go through. Even in those situations, we should like to mandate arbitration if the pre-litigation inspection and consultation meetings with the owners and developer doesn't resolve the matter, then we still like to mandate arbitration of claims instead of going to a court and going to a jury trial. That's residential projects. Now, commercial projects, they don't have the equivalent of a California Fix-It Law. So we have a little bit more discretion as attorneys representing the developer to write into the CCNRs and to reference those provisions in the CCNRs in the purchase and sale agreement with each buyer, to write in procedures in case there's potential claims or concerns about construction defects. But anything related to CCNRs, whether it's a residential project or commercial industrial, if it goes to court review for some reason because of some claims, the courts are going to use a reasonable standard. So as attorneys, we could maybe overreach in the CCNRs in an effort to protect the developer and write in all kinds of onerous procedures for the individual buyers and owners to go through to resolve any claims, and that would be counterproductive. So there's no magic answers to developers go, well, do what you can to protect me, and they'll ask me a lot of questions on, can't we make it a requirement of, let's say 90% of the owners have to agree before they get the right to sue us. And those things would be second guessed by the courts. So we have to, as attorneys, advise the client developer what's reasonable and make judgment calls in regarding what gets written into the CCNRs. The team that's involved with Kathy and me, as Kathy mentioned, the title company, then there's a budget preparer that prepares a budget for the association, and civil engineer that Kathy mentioned. Did I leave anyone out, Kathy, on that part of
No,
it?
I don't think so. Sometimes the architect is very involved, but other
Yeah.
times it's the developer who has all that information.
Yeah.
Yeah, the title company, the engineer, the attorney, and whoever the developer wants to bring in. Sometimes the developer does bring in early marketing people, and sometimes that can be very helpful. The budget preparer certainly should be involved early on. Sometimes a budget preparer can help the developer and the architect understand where there can be some budgetary cost savings. Most particularly as it has to do with utilities and how they're billed and whatnot.
One more thing I like to talk about, one last thing I like to talk about is on mixed use projects with the residential units and commercial units. It's very important to balance the rights of the residential condominium owners versus the commercial condominium owners, because the residential units are always there's gonna be a lot more residential units than commercial. If they belong to the same association, then you have to write in safeguards so that the residential units don't unfairly gang up on the commercial units and jeopardize the viability of the project by hamstringing or making it hard for the commercial units to operate. So we have to be very careful in that kind of situation. There's different alternatives to the setup. Sometimes we have a separate association for the commercial units and a separate association for the residential units. And then we have an agreement between the two associations. So if there's some kind of dispute, the dispute is not resolved by pure voting rights, because again, the residential units would always outvote the commercial units. I guess that's all I have to say. Unless you have something to add, Kathy?
No, I just wanted to bring up one minor thing about the budget. Certainly the budget's going to cover everything that's going to be a common expense, from insurance to monthly maintenance to management and reserves. But one thing that they won't have to deal with, at least ultimately, is property taxes. Property taxes will be segregated by the assessor and the tax collector the year following the recording of the condo plan. So this just brings into the importance of working with a title and escrow team that is familiar with the proration of taxes initially. And then just on the title company part, not all title companies have subdivision departments and work with subdivision projects. So it is important to make sure that the project starts with and ends with the same title company, and that it be a company that has and offers these services. So with that, we did not really get into phasing, but I'd like to, I think, Tim, too, to open it up to the group and see what questions that you have, and then we'll go from there.
I have to add one more thing. We were talking about the team. I left somebody important off the team, which would be the broker and real estate agent. Sorry about that. Because you guys are the ones selling the units. And so I always ask the developer, do you have a real estate broker agent involved? Because we want their input so that we don't do all the documentation and get it approved by everybody. And then at the end, the broker goes, wait a minute, why did we write it up this way? So it is important to get the real estate agent and brokers involved. And
also, Tim, in that vein, when we are marketing the project, the purchase agreement, do you get involved into drafting the purchase agreement for those commercial as well as the residential units?
Yes.
Okay.
And that's tough because each broker has their own style that they like in the contract based upon their experience or whatever. And there's so much variation you could have to purchase PSA, purchase and sale agreement, right, and escrow instructions that could be quite a bit of work back and forth with the developer and the real estate agents.
Yeah, but nevertheless, you help the owners to draft the PSA as well, right? And those
Yes.
are governing the documents.
Yes.
I don't think those are governing documents, but
right. You're right.
For the marketing, materials later on, after the project is finished, and then they are ready to be on sale.
Right.
For sale, I should say. Okay, that's great.
Okay, we have a question in the chat room. It says, to Mr. Murakami, did you ever work on a project which is involved air rights, make things more complicated? The air rights also involved with residential and commercial, new and existing. Do you review the REA and of course the CCNRs and all related documents.
Yeah, let's see, REA, reciprocal easement agreement, which is sometimes called a mutual benefit agreement. And I talked about if you have two associations, then commercial and residential, then there's some agreement between the two associations. So the REA could pertain to that. Now, what was the question about airspace rights?
Yeah,
Yes.
right, yes.
Okay, that,
Tim, we might be talking about an airspace map versus, because there's airspace rights where you might want to restrict
yeah,
the ability to be higher. And then there's airspace subdivisions, which I
Right.
think is maybe what they might be asking about.
yeah, Kathy, you could talk about that, but
Yeah,
when we talk about condominiums in a single building or series of buildings, then the condominium unit that the owner's buying is the airspace within the unfinished walls, the walls being a common area. So that's basic to condominium law about the airspace, but I think the question might involve more than that. And that's what maybe Kathy could talk about, the different
yeah,
types of projects with certain airspace rights.
yeah. Generally, we look at a subdivision map as being lots on a track, on the ground. But you can certainly have now airspace lots. So you can subdivide, you could in some respects eliminate your condominium plan by subdividing the property through airspace lots. This was done, I think, initially to satisfy some East Coast lenders who wanted to encumber lots and weren't crazy about encumbering airspace modules when you're trying to phase or subdivide. So yes, airspace lots can very much be done. In fact, Tim and I have just been working on a project where each floor is a different lot. And you know, it complicates things. Certainly your CCNRs have to cover all the easements and everyone's right to go through everyone else's, you know, elevator shaft and so on and so forth. But these are becoming more common and the cities are becoming more accustomed to them. So the trade-offs, why do airspace lots versus a condominium plan? It just depends on the lending situation. It depends on what's been on the tentative map, what was anticipated initially. But either way, you still structure your documents to make it work.
Yeah, I would add that some attorneys and some civil engineers overcomplicate it, and in getting into what Kathy talked about, having a subdivision tract map that's divided into different airspace lots. And my philosophy is to try to keep things simple. Keep it simple unless there's compelling reasons to make it more complicated. And I know Kathy agrees with me on that. So you got to be careful with some of that setup that you might see.
Yeah. Some of the reasons for doing it is they think that you could phase it, but really phasing has to do with how you're going to construct it. So if things have to be constructed at the same time because they're on different levels or they're connected or they're within the same building, then to subdivide it by airspace lots or to try to phase it doesn't make any sense, because you can't close, you can't sell something that's part of a structure that is not complete. And that sometimes gets overlooked.
Yeah, it seems that it's a complicated issue. Maybe Steve can call Tim or Kathy to pursue this issue more after the meeting. Is that okay, Steve? that's
Of
Steve.
course, of course.
Okay.
Yeah, because this air right have been purchased and been leased, and the meaning or the definition I mentioned about air right is, for instance, you have a project. The zoning, the CAR say that is a street, and you got say 20,000 square feet of the lot. So by code, you can build 60,000, and your height limitation, for instance, you can go as high as whatever you want, or maybe say up to say 100 feet. But you are only develop on this kind of maybe say 60 feet. So you have 40 feet left. Okay, that is air right. And this air right have been exchanged, have been purchased, or even leased by some of the developer. I know some of these kind of development in South Park, they are doing that. Okay, the things make it seem a little bit complicated. Is the case I'm involved with is the existing structure which is going to involve with the new development. So the new development, imagine this is say 100,000. Okay, now the 100,000 square feet, we have a FAI say 3, and we have a height limitation is 100. Some part have been used, some part has not been used. So on this particular smaller part, you can sell your air right to some developer, and you can parcel that out. So that is going to be very complicated, very, very complicated, because you are dealing with the existing, you are dealing with the new, and you have to incorporate of the existing CAR, I mean, not CAR, I'm sorry, CCNR, and REA, reciprocal easement agreement. So all of those, is very, very, very complicated. So that is my question, did Mr. Murakami or May,
Mhm.
had you ever deal with this kind of a situation so complicated?
Steve, I have not. I think the other part of that formula too is what the city's going to be willing to let you do within what you've purchased as your
City
airspace.
already approved.
Yeah.
Yeah.
Okay,
So-
maybe we should, for all fairness, for the other people who has questions, maybe we could have Steve consult Tim or Kathy later on this issue. Is that okay?
Oh, of course, of course.
Okay.
Thank
All right.
you very
I
much.
do have a question for Kathy. Is
Mhm.
that Kathy mentions that the lender has to approve the condo plan, right?
Yes.
Kathy? And then if they don't, and then you have to do a bridge loan for that in order
Well,
to move forward.
Yeah, your choices are limited. The lender, now understand that the lender is just consenting to the recordation of
Yeah.
the condo plan.
Right.
He's
right.
not consenting to separating out his payments. So he could say, okay, I'll sign your condo plan, but as soon as the first unit closes, I have to be paid off in full. So the
Mm,
lender certainly is not going to turn around and restructure the loan and say, oh, okay, here are your different payments amounts as loans close.
yeah,
So there are different levels of cooperation with the lender. And usually if it's the construction lender, they're cooperating completely.
yeah.
But if it's not, you're right. You could potentially have to pay them off, either cash them out, pay them off, or get another loan with a lender that will sign.
Yeah,
Yeah,
that would be disastrous,
Well, I'm often called upon to explain to the lender
Mhm.
that by signing the track map that
Mhm.
Kathy mentioned earlier, or the condominium plan,
Mhm.
that, as Kathy mentioned, it doesn't alter the repayment of their loan agreement. Therefore, I'm called upon to explain to the lender, by signing the tract map or signing the condominium plan, you're
Mhm.
not giving up your right to be paid off when sales occur.
Mhm.
That they're not, that doesn't mean they're agreeing to
Mhm.
partially paid.
Right. Okay. All right. Okay. Thank you. Also, another question is regarding the budget, Kathy. Yeah.
Mhm.
You said the budget is very important. I can agree more. Because if the budget is too high, that will affect the marketing of your condo units. And if it's too low, the DRE will not approve. So you have to tread between the fine lines there. So in that respect, how would you advise the developers in formatting or formulating the budget plan?
Well, if it's strictly a commercial condominium, you don't have the DRE approval
Right.
to contend with. That's just in a mixed use.
Mhm.
However, the needs of the project are the needs of the project. So fortunately, with a commercial condominium, you can possibly be more accurate about what your utility costs are going to be. The DRE has a worksheet and a formula, and you have to stick with their formulas on marketing and legal and accounting and utilities. But in a commercial condominium, you don't have those restrictions. You don't have to be within that box to develop your budget. So
Mhm.
you can work more directly with the utility companies and your mechanical engineer, for instance, to know a little more specifically how many BTUs are going to be used and how that can be divided up. You can do sub-metering once you know how your unit structure is going to be. You can go to a third party who does sub-metering for the utility companies, and they can get pretty specific. So it's important to know how many meters you're going to have and whether you want to go with a sub-metering situation so that those utilities are going directly to those users and not becoming part of the association.
If it is a mixed use project, it
Mhm.
has to be approved by the DRE.
Mhm.
So once the DRE is involved, it becomes more complicated in just budget analysis.
Yes, however, a good budget preparer can show the DRE how the commercial situation is separated and how those commercial utility uses are calculated by a different formula and still get it approved.
Mhm. I see.
It's still important, even on a entirely commercial industrial project where the budget is not going to be reviewed by the DRE, it's still important to be reasonable and not given to the temptation to make the budget as low as possible to make it enticing to the buyers.
Right.
Because
Okay.
after the owners take over the commercial industrial project, if they find out that the representation of what the monthly budget payment should be is inaccurate and unreasonable, there could be lawsuits filed against the developer. So you want to avoid that too.
Yeah. Good point. I have a question for Tim. For the commercial and residential projects, that there will be is treated differently as far as the construction defects concerned, right?
Yes.
For residential, you are governed by the civil codes, section whatever that is. But for commercial, it's more more leeway on that. But if you have a mixed use project, then how do you balance that kind of?
Yeah, the claims, it should be written so that the claims against the commercial claims arising from the commercial units would be handled differently and outside of the California Fix-It law, which applies to the residential condominium projects.
Right.
Now, there are laws and cases going way back that pertain to the sale of real estate in general, commercial or residential, even regarding defect claims. So there is some commonality to claims, whether or not it's commercial or residential.
Mhm.
That gets pretty complicated.
Yeah.
I try to consult with construction defect attorneys fairly regularly for insight into how I might write the documents up.
I see. Yeah, it's a good point. The last question, I hate to bother you so much. Is for the mixed use project, do you think it's a good idea to separate the HOAs? For the commercial and the residential, the portion?
Well, it's possible. You have to have at least 2 commercial units to create a separate association for the commercial project.
Mhm.
Recently, I've been leaning toward trying to create CCNRs and have both commercial and residential projects part of the same
Mhm.
project and same association, but just write into the CCNRs and write it fairly broadly that if there's claims or potential claims or disagreements, that it go into mediation and arbitration, and write it broadly so that the commercial owners can kind of be on a fair basis with the residential units. So to answer your question, I don't automatically say it's easy to separate out the 2 associations that create 2 separate associations.
I see.
You can still protect the commercial rights within, even if both are within the same project.
Okay. All right, thank you. Cesar, you have to unmute yourself. Cesar.
Yes, Peter, I was just saying that we're coming around the 12 o'clock hour.
Okay. So,
Are we all going? Are we invited to lunch somewhere?
yeah, you can have an electronic one.
Chinese restaurant in San Gabriel, of course, right?
Peter will pick up the tab.
Okay.
Yeah, sure, no problem. So, any other question from other
Well,
agents?
Peter, if you allow me to make a comment, I do thank you so much personally, because these kind of meetings are really enjoyed.
Yes.
Especially have someone so experts like Tim and Kathy that they know what they're talking about. I was coming across one of my clients that he was planning to buy a property on Cesar Chavez in East Los Angeles, and he was telling me, I would love to build a strip or shopping center over there, a small shopping center. After I hear everything that we need to go through, and in this, wow, I mean, it takes it takes a lot of things in consideration.
Yeah.
But beyond that, on all those entities involved, like CCR and other, which one supersede another one? I don't know if you guys understand my question. Let's say you submit the plans or whatever. Is any entity or organization that is say it's done like this? If not, it cannot be done.
I would say the city.
The city.
Yeah, so your friend, for instance, if he wants to develop a shopping center and it's zoned for a shopping center and he's not planning to subdivide it, then he goes right in with an architect and starts pulling his building permit.
Okay.
It's when he wants to subdivide it and separate things out and do mixed use that it throws on this layer of complexity.
Okay.
Yeah. But you always, personally, to me, you always start with the city.
Yeah.
All right.
And they might like a shopping center. Very much.
Is there a number, Tim and Catherine, that we can reach out to you, or we go through Peter in the event that we have clients to refer to you guys, or how do we go about that?
Peter could email, has our contact information, right? Based on our emails of Kathy
Yeah.
and so he could send that out.
Okay. I'll do that. Yeah, in case anybody needs help from Tim or Kathy, just let me know. Okay.
Beautiful.
Okay, Peter, I'm gonna take note over here about the lunch that you owe us. Such a great, for such a great class.
No problem. No, I'll
I
come
will
in
keep
and
remind you
afford it,
about
no
that,
problem.
okay?
If you can come to claim it. Yeah. So any other questions for Tim and Kathy? I mean, it's such a enlightening,
Mhm.
educational seminar for us. It's really very, very helpful, and we appreciate it very, very much, Tim and Kathy. Yeah, I hope that maybe later on you can come to talk to us again in
Mhm.
more in depth. I don't know this 1 hour is hardly enough for
It's not enough. No.
yeah for these topics, so maybe well, later on we can invite you again to talk in more in depth. Appreciate it.
We would very much enjoy that. Thank you.
Thank you.
Thank you.
Okay.
Any
Okay.
final words that you had to say, Peter, to wrap up the
No,
meeting?
I think that's it.
Right.
Yeah.
1 month from now, we are going to be talking about REO's property. So keep it in your calendar. You'll get the invitations. And thank you, all the agents, all commercial agents, and all the residential agents that want to become commercial agents. Coldwell Banker Church Realty is right behind you. Anything you need to do, management, owners are delighted that we will be searching for all of these resources. We have contacts all throughout the San Gabriel Valley, and we'll be delighted to point you in the right direction. With that,
Right.
Thank you very much. Thank you, team. Nice meeting you.
Thank you.
Thank you.
Thank
Take
you. Thank
care.
you.
Take
Be
care,
well.
everybody. Yeah. See you next month. Bye-bye.